This is Federalist 50, Part 2. I'm going to start with paragraph 3. I hope you listen to the first part, as that will explain things a little bit more. The scheme of revising the Constitution in order to correct recent breaches of it, as well as for other purposes, has been actually tried in one of the states. One of the objects of the Council of Censors, which met in Pennsylvania in 1783 and 1784, was, as we have seen, to inquire whether the Constitution had been violated and whether the legislative and executive departments had encroached on each other. This important and novel experiment in politics merits, in several points of view, very particular attention. In some of them, it may, perhaps, as a single experiment made under circumstances somewhat peculiar, be thought to be not absolutely conclusive. But as applied to the case under consideration, it involves some facts which I venture to remark as a complete and satisfactory illustration of the reasoning which I have employed. In part 1, I said that Madison talks about the Council of Censors of Pennsylvania and its work between 1783 and 1784, and how these people who were supposed to be impartial in looking at the work of the legislature and to see also the workings of the Constitution, how they couldn't come to agreement on things because they themselves belonged to the different parties, different groups, different factions, and were always fighting while they were working on seeing whether the Constitution and whether the legislature actually, or the legislative branch had violated the Constitution or not. So Madison says, we can, just looking at that example, we can see that if we have conventions, the same thing is going to happen to conventions, whether they are occasional, every once in a while, or whether they are periodical. They are set at set times, every 5 years, every 10 years, every 15 years. It says either way, you're going to have a group of people that are going to be taking one side or another. They're not going to be impartial. So I'll continue reading first. It appears from the names of the gentlemen who composed the council that some, at least, of its most active and leading members had also been active and leading characters in the parties which pre-existed in the states. Second, it appears that the same active and leading members of the council had been active and influential members of the legislative and executive branches within the period to be reviewed, and even patrons or opponents of the very measures to be thus brought to the test of the Constitution. 2 of the members had been vice presidents of the state, and several other members of the executive council within the 7 preceding years. One of them had been speaker, and a number of others distinguished members of the Legislative Assembly within the same period. So even if you have conventions to overlook the workings of the branches of government, these conventions are going to be composed of people who've already been part of the problem, who were working and created the problem, who were working for the government and created the problem. Third, I'll continue with the Federalist. Third, every page of their proceedings witnesses the effect of all the circumstances on the temper of their deliberations. Throughout the continuance of the council, it was split into two fixed and violent parties. The fact is acknowledged and lamented by themselves. Had this not been the case, the face of their proceedings exhibit a proof equally satisfactory. In all questions, however unimportant in themselves or unconnected with each other, the same names stand invariably contrasted on the opposite columns. Every unbiased observer might infer, without danger of mistake, and at the same time without meaning to reflect on either party or any individuals of either party, that unfortunately passion, not reason, must have presided over their decisions. When men exercise their reason coolly and freely on a variety of distinct questions, they inevitably fall into different opinions on some of them. When they're governed by common passion, their opinions, if they are so to be called, will be the same. So either way, passion is going to take over. Maybe a little bit, maybe a lot. Fourth, it is at least problematical whether the decision of this body do not, in several instances, misconstrue the limits prescribed for the legislative and executive departments, instead of reducing and limiting them within their constitutional places. Fifth, I have never understood that decisions of council on constitutional questions, whether rightly or erroneously formed, have had any effect in varying the practice founded on legislative constructions. It even appears, if I mistake not, that in one instance, the contemporary legislature denied the constructions of the council and actually prevailed in the contest. This censorial body, therefore, proves at the same time by its researches the existence of the disease, and by its example, the inefficacy of the remedy. This conclusion cannot be invalidated by alleging that the states in which the experiment was made was at that crisis, and had been for a long time before, violently heated and distracted by the rage of party. Is it to be presumed that at any future septennial epoch, the same state will be free from parties? Is it to be presumed that any other state at the same or any other given period will be exempt from them? Such an event ought to be neither presumed nor desired, because an extinction of parties necessarily implies either a universal alarm for the public safety or an absolute extinction of liberty. Where the precaution taken of excluding from the assemblies elected by the people to revise the preceding administration of the government all persons who should have been concerned in the government within the given period, the difficulties would not be obviated. The important task would probably devolve on men who, with inferior capacities, would in other respects be little better qualified. Although they may not have been personally concerned in the administration, and therefore not immediately agents in the measures to be examined, they would probably have been involved in the parties connected with these measures and have been elected under their auspices. It's almost like having huge fans of two sports teams becoming officials of a game between these two teams. Bias is going to be there. If conventions are formed, whether they are occasional or periodic, the people who will be in those conventions are going to be already taking the side of one side or the other. They will be biased, and it beats the purpose. It just won't do any help, and what it does, it just decreases the respect that people will have for the Constitution, and for the government under that Constitution, because they won't see any stability in it. They'll see change on and on and on, and that is not good. So in the starting next video, we will do another one of the very important Federalist Papers, Federalist Paper 51,